Hi, and welcome to this latest immigration law conversation. Today, I'm joined once again by Priya Solanki. Priya is an expert immigration law barrister, and Priya is here today to talk about a new book she's written. Priya, thank you once again for joining me. Just for those of you who don't know you, tell us a bit about you and what you do.
Firstly, Adam, thank you for having me. I'm Priya Solanki and I'm a barrister at One Pump Court Chambers in London. I don't usually sound so horsey. I have got a bit of a sore throat at the moment. I specialise in immigration, asylum and human rights law, and I've got a particular interest in gender violence cases, including domestic violence, trafficking, FGM, and this really is what has led to me writing a book on the topic of domestic violence and the changes.
Yes, you wrote this new book. Just you've sort of hinted at there what it's about. Just give us a snapshot of the book and what it's about.
Sure. So it does cover quite a lot of topics, actually. So the book deals with the new concession on migrant victims of domestic abuse concession, which used to previously be the destitution domestic violence concession, and the changes that have been brought in through the new concession. We also look at the new immigration rules for victims of domestic violence applying for settlement. So that's Appendix victim of domestic abuse. And within that, I look at the immigration rules, the changes in the rules, and I highlight those and how those are beneficial or not, how the rules have been interpreted by courts and tribunals. I look at the evidential requirements in the rules and the authorities and the updated policy guidance that accompanies these rules too. I also have a look in detail at the new rules that deal with transnational marriage abandonment, which is a really important issue that's finally been brought in to scope within these rules following a challenge to the rules not dealing with this scenario that was dealt with by the courts. I look at child victims of domestic abuse and, importantly, child dependents of victims of domestic violence, and how there's different requirements for child dependents and the issues to be careful about in that regard. Challenging adverse decisions, there's a chapter on that, and we look at where we are with rights of appeals. We look at admin review and judicial review. There's a chapter on Appendix CU for victims of domestic violence as well. And importantly, there's a chapter on claims outside the rules, because under the new policy, it is possible to still seek leave, even if you don't meet all of the requirements of Appendix victim of domestic abuse. So there's some useful stuff in there for those individuals.
Yeah, I was going to say when I looked through the book, chapter 7 on using the policy guidance, I thought was really helpful to see what concession there is outside the rules still within the policy, and that was really helpful. Priya, you started there by talking about what was the domestic DDVC, the domestic violence concession, which has now changed. Can you just give us a bit more detail on what's changed in relation to the policy?
Yes. So for those that aren't familiar with the policy, I'll just explain that the concession was brought in to allow victims of domestic violence to apply for 3 months leave outside of the rules so that they're able to flee their matrimonial home and claim benefits and gain access to a refuge. As many will be aware, when individuals have leave as a spouse or a partner, there's usually a condition attached to their leave that says no recourse to public funds. So there's not been any negative changes. So nobody's lost entitlements or rights under the new concession. Everybody that used to be eligible under the DDVC concession remains eligible under the new concession. But the migrant victims of domestic abuse concession is broader in respect of who can apply. So whilst the old concession only allowed those who were able to apply for settlement as a victim of domestic violence to apply, the new concession also allows the partner of a student migrant or the partner of a migrant on a work route to seek leave outside of the rules for 3 months. However, whilst these individuals are able to apply under this concession, that doesn't mean that they're then able to go on and apply for settlement. And so this chapter of the chapter of the book that deals with the concession explains how it's really important that individuals get proper advice on that situation before going on to make an application under this concession.
Yeah, I think that's so important. People might rush in thinking, wow, it's expanded. I can get you 3 months leave to remain outside the rules without thinking through the consequences of that. In terms of the substantive rules, you hinted earlier that at the start of this year, the rules were consolidated and somewhat expanded into Appendix Victim of Domestic Abuse. Just can you give us an overview of what the requirements of the rules are now? I appreciate in this summary video, there's a lot to go through. In your book, you helpfully look at validity, suitability, eligibility, but just give us a broad overview.
Of course. So at the start, I'll highlight that there's a chapter on transnational marriage abandonment, and that is a chapter in itself because the rules and the policy are different. For example, there's a different standard of proof for transnational marriage abandonment cases. I'll also highlight that the requirements for children are different and they're complicated and they need to be considered with care. But the general requirements are, firstly, that an individual needs to make a valid application. And this book deals with in detail what that means. So filling out the right form, paying a fee waivers, biometrics, having the right identity documents, what to do if you don't have those. Secondly, suitability requirements, so Part 9 of the general grounds of refusal and the exception to that for domestic violence applications. Thirdly, the eligibility requirements. And so the eligibility requirements include the relationship requirements, so having leave in the right route as a partner. That's really important to check because particularly because of this change with the Migrant Victims of Domestic Abuse concession. And secondly, demonstrating that the relationship has broken down permanently owing to domestic violence. And in that regard, the new rule is contained in VDA 4.2. And I think it's important to highlight that this version and this wording of VDA 4.2 is very different to what appeared in EDVILR 1.3. And the chapter of the book that deals with the requirements of the rules explores this in detail and explains how it's a beneficial change to many applicants.
Yeah, no, that definition is really helpful, and that is a positive change. For people who've followed us this far in the video, let's reward them with some practical tips, because I'm sure they want some practical advice from you, Priya, just in terms of some practical takeaways for people preparing domestic abuse applications, whether it's under the policy, transnational marriage abandonment, whatever you want to give us, in terms of some practical highlights for people.
Okay, so where most applications are refused is on the evidential requirement. It is, of course, very difficult to evidence domestic violence, and that's long been recognised by the courts and tribunals. So the starting point is the more evidence that you can gather, the better it's going to be. But of course, there is this appreciation that it's really very difficult to gather evidence, and the case law acknowledges this, as I say. So what a good tip is to take a very detailed witness statement from the applicant. And it's important that if there's a lack of evidence, say, for example, if they've been to a GP but not disclosed these issues, or they call the police out, but then once the police got there, they didn't actually raise any allegations of domestic abuse. It's important these issues are grappled with in any statement so that the Home Office are able to understand why there's a lack of evidence. And there's case law on why it's so important that those explanations are offered. Also, it's important for practitioners to remember that the test is whether the relationship has broke down permanently as a result of domestic violence. Now, relationships are very messy and they break down for a multitude of reasons. And so it may require really careful thought when going through evidence to explain how it is that the relationship broke down permanently as a result of domestic violence. And there's case law on that, LA, Pakistan from 2009, which speaks about how evidence must be assessed in the round, the totality of the evidence must be considered, and that it must be remembered that even if different reasons are given on a divorce application or before a court, the marriage may still have broken down permanently as a result of domestic violence. Another tip is use the policy guidance where it helps you. There's a lot in there now, particularly with the updated guidance, that is very useful. And I've highlighted that at length in the book. Also, remember important decisions like Ishtiaq from the Court of Appeal in 2007, Balakui from the High Court in 2012, and Suleiman, a more recent decision from 2020, and refer to them in submission so the Home Office are reminded of what the test actually is when they're looking at the evidence. Or another tip that I'd like to give is think about the complexities that arise with EUSS leave before jumping into making any application. And also think about individuals who don't meet the rules and how the policy might assist them with still making an application. All of this is, of course, covered in the book.
No, 100%. And actually all those cases you refer to, I've seen in the book, the references and the extract from the cases are there. I think what you say about the witness statement and going into the detail is so important and often overlooked in applications, because we know that they're often refused by the Home Office on the basis that it hasn't been established the relationship was broken down because of domestic violence. We've talked a lot about the book. Tell people how they can get hold of that, and anything else you want to share with us, Priya.
Of course. So the book is available in a number of places, for example, Waterstone, Wildies, Amazon, which I think provides delivery within a couple of days, and also on the publisher's website, which is Law Brief Publishing. There's also a free chapter on Law Brief Publishing websites, Law Brief Publishing's website too. So yes, hopefully it will be a useful tool for practitioners in preparing applications and also challenging adverse decisions.
That's really helpful, Priya. And for people watching or listening, I've put below this in the description a link to Law Brief Publishing where you can get the book, and also to the free chapter on the Law Brief Publishing website. Priya, thank you so much. This is such an important area, and it's such a difficult area often, and there are some helpful changes, but also some complexities that the new changes throw up. So I think what your book does is really help us navigate that in a practical way and help us in preparing successful applications. So thank you so much, Priya, for joining me again today.
Thank you so much, Adam. Thank you.